It's not connecting. Wow. Well, has he connected before? Has she connected? Registrar. If they cannot connect, then we'll reschedule it.
Hello, we're here. Wow, I can hear you. I can see you.
Is it first defendant or second?
First and third defendants. The second defendant called.
The second defendant.
It's connected.
What of the claimant?
Does this, I don't know this unidentified number, whether that is.
Yeah.
As a link up, I don't know.
We are trying to get the claimant to connect with us.
Okay, let me also try and see that. I've been able to get the claimant counsel. The second defendant said is inside the court as I speak. Then the claimant I got him, he said is somewhere around Ogoni. He's not there. I cannot connect, but he had asked his colleagues to connect. And I told him if they cannot, he can't tell me. I mean, if they cannot connect, they should be in court. And he said, well, he will try and see if he gets to them.
The second defendant is already in court.
That's what I'm saying. The second defendant.
The second defendant is already in court. It is the claimant that we are yet to. get
Yes,
in
I
touch with?
reached him. I got in touch with the claimant now. He said he's in somewhere Ogoni,
Yes,
which is far off from here. That he asked his colleague to connect. That he doesn't know why they've not connected. I said if they are finding it difficult to connect, they should be in court. And that's usually what I know. If the person can connect, because the
yes,
registrars most times are in court, they should be in court. It's okay, you will try and
yes.
see if language is that if he can get them. So I don't know. If he got this text at the same time with us, I mean, he should have taken this more seriously. So Lord, I don't know if it cannot be a reason why he cannot.
That is it.
Lord, we are ready to.
The claimant himself, can he connect?
Lord, the Clement Council called back. He said, called his colleagues and they said they are somewhere very far off from court. That
Yes.
whichever it comes, they can always apply and get a CTC of the judgment.
So he abandoned his right to be present or connected.
That's what is in this so we can explain this.
All right. Where is the registrar? Yes, let's go ahead.
Good evening, everyone. Suit number NICN/PAC/28/2023 between Mr. Tango Sani and Nigeria Communication Commission. Claimant was present.
Is claimant present?
Yes, was present. Okay.
Yes, appearance.
Allow me, please.
Yes, yes,
My name is Emeka Onyeka.
yes,
Appearance is for the first and the third defendants.
yes,
Now we sincerely apologize for the absence of the defendants.
yes. Yes, yes. VW. Yes. Yes, this matter was last adjourned for judgment, and judgment was not able, I was unable to deliver the judgment. But we all know the provisions of the Constitution. The judgment now is ready. If it does not occasion miscarriage of justice, the court can still go ahead to deliver it. Or if any of you has anything objection to that, let me know so that I record it down. Yes, counsel to the first and third defendant.
Lord, we have no objections. We urge the court to go ahead and
Yes, the second defendant? Yes? Okay. All right. This is the judgment. This suit was commenced by claimant against the three defendants by an originating process as in Form 1 general form of complaint pursuant to Order 3, Rule 1, Sub 1 and 2 of the National Industrial Code of Nigeria Civil Procedure Rules 2017. The process was filed on the 13th day of March 2023. The claimant claims against the defendant jointly and severally the following reliefs. 1. A declaration that the alleged termination of the claimant's appointment on 2nd January 2023 via SMS is improper, wrongful, illegal, unconstitutional, and therefore null and void, and against the principles of natural hearing, natural justice, or fair hearing as the case may be. 2. An order setting aside the alleged termination of appointment of the claimant from the services of the first and second defendants, and consequential order of reinstatement enjoining the second defendant to pay to the claimant all his accrued and withheld salaries, other emoluments and their benefits from 2nd January 2023 till the date of judgment in this suit. 3, the sum of 5 million naira against the third defendant being damages for malicious instigation and procuring the wrongful termination of appointment of the claimant from the services of the first and second defendant. The sum of 5 million naira against the third defendant as damages for defamation of character for maliciously and falsely alleging that the claimant stole chicken legs parts which the third defendants knew to be false. 5, the sum of 2 million naira as damages for breach of the contract between the claimant and the second defendant and cost of litigation. The originating process, in line with the rules of court, was accompanied by a statement of facts, witness depositions, and the documents intended to be relied upon during trial. In reaction to the suit, the first and third defendant jointly filed a statement of defense on the 15th day of March 2024, while the second defendant filed his statement of defense on the 10th day of May 2024. The first and third defendants' counsel amended their statement of defense filed on the 5th day of November 2024. The claimant, on his part, filed a reply to the first and third defendants' joint statement of defense on the 27th day of March 2024, and claimant's reply to the second defendant's statement of defense. It was filed on the 20th May 2024. The defendants also filed a notice of preliminary objection, challenging the competency of the suit and jurisdiction of this court. The two objections were heard on the 1st July 2024, and ruling was adjourned to be taken along with the main judgment. At the hearing of the case, claimant testified with one other witness. He tendered 3 documents marked as Exhibit CW1A, CW1B, and CW1C. They are termination of appointment text message, claimant solicitor's letter, and the first defendant's letter. Also, a document was tendered through CW1 during cross-examination. The document was marked as Exhibit D1. Counsel to the first and third defendant in their defense called one witness and tendered documents through the witness marked as Exhibits D2, D3, and D4 respectively. She was duly cross-examined. Thus, the witness was duly cross-examined by the claimant's counsel and counsel to the second defendant. The second defendant, on his part and in defense to this instant suit, called one witness and tendered documents marked as Exhibit D5, D6, D7, and D8 respectively, though the claimant's counsel indicated intention to oppose the admissibility of Exhibit D8, professional fee receipts. At the conclusion of hearing, parties filed and exchanged their respective final written addresses. The first and third defendant joint final written address was, as well as second defendant final written address, were all filed on the 19th day of May 2025, and the claimant's final written address was filed on the 23rd June 2025. Issues for determination. Counsel for the first and third defendants submitted loan issue for determination. The second defendant submitted 2 issues for determination. The claimant also adopted similar loan issue for determination. After careful consideration of the issues formulated by the parties, it is obvious that both the issues submitted by the claimant counsel, the first and third defendant counsel, as well as issue 1 of the second defendant counsel, are similar in nature, as all of them bordered on the burden of proof. I therefore adopt the issue 1 submitted by the second defendant counsel as the main issue for determination of this suit. It reads, whether from the totality of evidence before this honorable court, the claimant has proved his case on the preponderance of evidence to be entitled to his claims sought in this case. A legal submission, that one is very lengthy. So you know your argument in your final written address. Then I'll go straight to the decision. The defendants have raised preliminary objections challenging the competency of this suit and jurisdiction of this court over this matter. First is the first and third defendant's notice of preliminary objection, dated and filed on the 15th day of March 2024. The applicants challenged the competency of the claimant suit and the jurisdiction of this honorable court to hear and determine this suit. The grounds of the preliminary objections are that the first and third defendants applicants are not the proper necessary parties to be sued in the instant suit. The suit was commenced in default of the pre-action notice as provided in the National Commission Act. The subject matter of this suit does not fall within the jurisdiction of the Honorable Court. The applicant filed along with the preliminary objection a written address as their argument in urging the court to uphold their objection and strike out the suit, or alternatively strike out the names of the first and third defendants in this suit. The claimant responded and filed a claimant's reply to the first and third defendant's notice of preliminary objection. The process was filed on the 27th day of March 2024. The claimant's counsel adopted it as his argument in urging this court to overrule the objection. Parties formulated issues for determination of this preliminary objection. First and third defendants' counsel submitted the following issue for determination: whether the first and third defendants, whether the first and third defendants are the claimant's employers, the proper parties to be sued in the instant case, and there being any cause of action against them. Whether the Honorable Court has the jurisdiction to hear and determine an action on defamation of character. The claimant counsel also submitted the following issue for determination of this objection, preliminary objection. A, whether the first and third defendants are proper and necessary parties to this action against them. Whether the Honorable Court has the jurisdiction to hear and determine an action of defamation of character as ancillary to the principal relief. Whether the first and third defendant joint statement of defense is a valid and competent process before the court upon which the notice of preliminary objection can stand. Perusal of the full set of issues submitted by the parties postulates that the issues submitted by the counsel to the first and third defendant can conveniently cover issues A and B submitted by the claimant's counsel, while on issue C that relates to the competency of the first and third defendant's statement of defense, it is an objection of itself that cannot be taken along with this preliminary objection, challenging the parties' competency of the suit as well as jurisdiction of this court. The claimant's originating process is to be considered in determining the objection. Therefore, the two adopted as the issues for the determination of this submitted that from the claimant, learned counsel for the first and third defendants submitted that from the claimant's statement of fact and deposition in the witness statement on oath, nothing points out that the first and third defendants are the claimant's employers. He also contended that there is nothing on record or before the court to suggest or even insinuate that the first and third defendants are shareholders or directors in the company that employed the claimants and of privy to any terms of the claimant's appointment. There is equally nothing on record or at all before the court to show that the first and third defendants are directly responsible for the payment of claimant's salaries, wages, or play any role in the manner the claimant's employer, being the second defendant, runs the affairs of his business. He further submitted that the status of the second defendant is one of an independent contractor engaged to provide cleaning services to the first defendant counsel. Counsel relied on decided cases, which I reproduce here, and submitted that the claimant, having failed to show that the first and third defendants were his employers or privy to the terms of his employment contract, with the second defendant, and the alleged SMS terminating his appointment was not sent by the first or third defendant. He urged the court to resolve this issue in favor of the first and third defendant and strike out the instant suit for want of jurisdiction. The claimant on this issue responded by reproducing paragraphs A and B of his statement of facts and submitted that in determining the jurisdiction of a court over a particular matter, it is the claimant's claim that determines jurisdiction. Drawing strength from the pleadings of the claimant, it is obvious that the first and third defendants are proper and necessary parties to the present action. The first defendant from the pleadings of the claimant is the principal of the second defendant. Both the first defendant and second defendants had a contract that brought in the claimant as an employee and has been working in the workplace of the first defendant until the purported termination of the claimant's employment. The third defendant is the zonal coordinator and head of the Port-Harcourt office of the first defendant. She was alleged to have instigated and caused the termination of the claimant on the allegation that the claimant stole some chicken parts. He cited the case of Ora versus Ora and other cases that I produce here, and the citations also provided. And he urged the court to discountenance the argument of the first and third defendants and dismiss their objection as lacking in merit and hold the first and third defendant as proper and necessary parties to this action. It is established principle of law that a party in a case is any person whose presence is crucial and fundamental to the resolution of a matter before the court. Such a person must be made a party to the proceedings. The only reason which makes it necessary to make a person a party to an action is so that he should be bound by the result of the action, and the question to be settled, therefore, must be a question in the action, which cannot be effectively and completely settled unless he is a party. See the cases of Okelu versus Medicom, Rimco Construction Limited, and VP, all citations provided. That is, the question to be determined in the action must be such that cannot be effectively and completely settled unless the person sought to be joined is made a party to the action. The test is whether the person to be joined will have his interest irreparably prejudiced if an order joining him is not made. See Imagu versus Asibelu, Oyekweli versus INEC, all citations provided. In the instant case, the allegations made by the claimants against the first and third defendant can only be completely and effectively determined by joining them as parties to this case. By making them parties to this case will enable them to state their own parts in the matter and thus completely and effectively decide the matter by this court. Therefore, even if the first and third defendants are not parties to the employment contract, this issue is resolved in favor of the claimants against the first and defendant. On the second issue, learned counsel for the first and third defendant argued that this court lacks jurisdiction to entertain matters bordering on the defamation, while the claimant submitted that this court has jurisdiction as the relief bordering on defamation is not principal relief, but ancillary relief, which is based or connected to the principal relief. This court in several cases declined jurisdiction on matters that are tortious in nature, especially defamation of character, or in the case of medical and health workers versus Ehigiba, 20 of the citations provided, as rightly cited by the claimant's counsel, the Court of Appeal held that Section 254(1) of the Constitution of the Federal Republic of Nigeria has given NIC a wider power to exercise jurisdiction on the matter. Again, in a recent decision of the court also stated that the court lacks jurisdiction to entertain tortious matters that are tortious in nature. At this juncture, I must state that we are bound by the doctrine of judicial precedent. A later decision of the Court of Appeal held that this court lacks jurisdiction to entertain matters relating to torts of defamation of character. Therefore, I accordingly declined the jurisdiction. On the claimant's issue of validity of the first and third defendant's joint statement of defense, this is notice of preliminary objection challenging the competency of the suit and jurisdiction of the court. This, in my view, has nothing to do with the defendant's pleading. The law only allows the court, in addition to affidavits filed by the parties, to consider the originating processes filed by the claimants only in determination of the preliminary objection. Claimants only. Determination of preliminary objection has nothing to do with the pleadings filed by the defendants. Claimant counsel is therefore ordered to raise and argue his objection at the appropriate time. In conclusion, the preliminary objection filed by first and third defendant is hereby overruled to the extent that this court lacks jurisdiction on matters of defamation of character. Here I must state that though issue of pre-action notice was made as a ground by the learned counsel, but failed to argue same, and so the claimant counsel did not respond to that. The second defendants filed a notice of preliminary objection challenging the competency and jurisdiction of this court over this case. The notice of preliminary objection was filed on the 10th day of May 2025. It prayed for the following reliefs. One, an order of this honorable court striking out and or dismissing this suit as same discloses no reasonable cause of action against the second defendant. An order of this honorable court striking out and or dismissing this suit for want of requisite jurisdiction and for any further orders that this honorable court may deem fit to make in the circumstances of this case. The objection is predicated on 5 grounds, supported by 10-paragraph affidavit, 3 annexures marked as exhibits A, B, and C. There is also a written address filed in compliance with the rules of court. The written address is the counsel's argument in urging the court to uphold his objection. In reaction to the objection, the claimant's counsel filed a claimant's reply to the second defendant's notice of preliminary objection. The reply was filed on the 20th May 2024. The second defendant counsel, in his written address in support of his objection, formulated 2 issues for determinations as follows. 1, whether the case of the claimant discloses any reasonable cause of action against the second defendant for the court to assume jurisdiction to entertain and determine same. B, whether the court has the requisite jurisdiction to entertain the claimant's suit, wherein the facts giving rise to the claimant's relief before the court borders on defamation of character. These issues were also adopted by the defendant's counsel in his reply with an additional issue on the competency of the second defendant's pleadings. This court therefore hereby adopts the 2 issues submitted by the second defendant counsel for the determination of the preliminary objection. On issue 1, learned counsel on behalf of the second defendant submitted that the case of the claimant disclosed no reasonable cause of action against the second defendant. In this suit, the claimant's case is that he was employed by the second defendant sometimes in 2018 to work in the first defendant's Port-Harcourt zonal office as cleaner. On the 2nd January 2023, the second defendant terminated his appointment following the instigation of the third defendant over an allegation that the claimant stole a chicken part. Counsel argued that the claimant's case is not that he was employed by the second defendant under probation in June 2022, but he was employed since 2018 to determine the course of action. The court will have to look at the claimant's employment from 2018. so as to ascertain whether his termination of employment in January 2023 was proper. Counsel cited the cases of Rimco Construction Company Limited versus Beefy Industries Limited, Loy and another versus New Life Microfinance Bank Limited, Concom Telecommunications Limited versus MTN, and a host of other cases, all citations provided. He further argued that the claimant did not disclose in his suit before this court any ascertainable legal rights that accrued from 2018 to 2022 in his alleged employment by the second defendant. As such, his suit is bound to fail for failure to disclose a reasonable course of action against the second defendant. He urged the court to strike out or dismiss this suit for want of jurisdiction, as the suit has not disclosed any reasonable course of action against the second defendant. The claimant counsel, on the other hand, referred this court to the opening statement of material facts leading to the institution of this case, and submitted that in determining the jurisdiction of the court, it is the claimant's claim that determines the jurisdiction. Drawing strength from the pleadings of the claimant, it is obvious that the claimant's claim before the Honorable Court discloses reasonable course of action against the second defendant. The second defendant employed the claimant and terminated his appointment. Counsel relied on the case of Odunta versus Akibu and submitted that the claimant claim before this Honorable Court disclosed reasonable course of action against the second defendant as well as the first and third defendant. Now I have perused the arguments canvassed by parties in their respective written addresses. The law is that a reasonable course of action is a course of action with some chances of success. For a statement of claim to disclose reasonable course of action, it must set out the legal rights of the plaintiff and the obligation of the defendant. It must then go on to set out the facts constituting infraction of the plaintiff's legal right or failure of the defendant to fulfill his obligation in such a way that if there is no proper defense, the plaintiff will succeed in the relief or remedy he seeks. See the cases of Thomas and others versus Olufoshoi, Ibrahim versus Osim, Oshoboja versus Amuda, Prince Waterhouse versus Mr. John Momo, all citations provided. In the case of Rimco Construction Company Limited versus Beefy Industries Limited and another, where the Supreme Court stated the principle thus: a reasonable course of action which connotes setting out the legal rights of the plaintiff and the obligations of the defendant and disclosing the infraction of the plaintiff's legal rights and failure of the defendant to meet up with his or her obligation. The next question to ask and answer is, what determines whether a suit or action discloses a reasonable course of action? It is trite that to determine whether a suit or action discloses a reasonable course of action, it is the plaintiff abatement contained in the statement of claim that will be looked at and considered only. Thus, to determine what constitutes a reasonable course of action, it is important to examine the abatement in the plaintiff's statement of claim and see if the abatement discloses some course of action or raises some questions fit to be decided by court. See the case of Irene Thomas versus Dr. Olofoshoe, Henry Stephen Engineering Company Limited versus S.A. Yakubu, Chief S.A. Dada and three others versus Otumba Adeniran Ogunsanya and another. All citations provided. In the instant case, and as rightly pointed out by the claimant's counsel in the opening paragraphs of the claimant statement of fact, the abatement discloses some course of action and raises some questions fit to be decided by the court. The second defendant was the employer of the claimant, and that the claimant's employment was wrongfully terminated via SMS by the second defendant as alleged. The contention of the learned counsel for the second defendant, that is the claimant's case disclose no reasonable course of action is misconceived because facts in the claimant's statement of facts must be delineated from evidence to prove or show reasonable course of action. Accordingly, this issue is resolved in favor of the claimant against the second defendant. On the second issue bordering on defamation of character, counsel cited the case of EcoBank, Nigeria Limited and others versus Idris, and submitted that by Section 251C sub 1 of the Constitution of the Federal Republic of Nigeria 1999 as amended, this court has no jurisdiction on defamation of character. He urged the court to strike out or dismiss the suit of claimant in its entirety. It is not the duty of court to carry out surgical operation on the claimant's case or lend helping hand to the claimants when the suit itself is grossly incompetent and robs the courts of requisite jurisdiction to entertain same. The claimant, on the other hand, contended that this court has a requisite jurisdiction to hear and determine the claimant's relief for in paragraph 14 of the statement of facts, bordering on defamation of character. He submitted that the relief is an ancillary relief which is based or connected to the principal relief and arose out of the employment and in the workplace of the claimant and the defendants. And the defendant's counsel cited, and the defendant's counsel cited and relied on the cases of Adenugo versus Odumeru and medical and health workers versus Ehigigba. All citations provided, and further submitted that the present suit before this court, which relates to relief 4 of the claimant's relief, is defamatory relief and is defamatory relief and is defamatory relief and ancillary to the principal relief, raising from a purely labor and employment relationship arising from the workplace and relating to or connected with labor employment dispute as envisaged by Section 254 sub 1A of the Constitution of the Federal Republic of Nigeria as amended. He therefore urged the court to hold that it has jurisdiction to try and hear the issue of defamation as ancillary relief to the principal relief. A careful perusal of 2 decisions of the Court of Appeal cited by the claimant's counsel and second defendant's counsel, the authorities favored their respective contentions. By the doctrines of judicial precedent, a later decision prevailed over the earlier decision of the appeal court, even if it is not overruled or set aside. The decision of the Court of Appeal in EcoBank Nigeria Limited and others versus Idris, decided in 2021, cited and relied upon by the second defendant, is more recent than the case of medical and health workers versus Ehigbo that was decided in 2019. In this case, I have no option than to adopt the decision of my learned brother, A.O.A. Obaseki Osage J, in the case of Oduka Etim Odo versus EcoBank Nigeria PLC and another, rightly cited by the counsel for the first and the third defendant. The judgment delivered on the 13th day of January 2025, where my lord stated that, however, this court is bound to follow the most recent Court of Appeal decision in EcoBank Nigeria Limited and another versus Idris, that the jurisdiction of the National Industrial Court of Nigeria cannot be expanded to cover claims in defamation. I decline jurisdiction in respect of relief 5 and 6. In the instant case, I therefore decline jurisdiction to entertain claimants' claim bordering on defamation of character, and relief 4 therefore is accordingly struck out for want of jurisdiction. The counsel for the second defendant also argued that The claimant suit is bound to fail for manifest failure to comply with the mandatory pre-action notice required by law when suing the first defendant. The requirement of 1 month notice was not complied with. As such, the court lacks jurisdiction ab initio to entertain the claimant suit. Earlier on, I made a comment in the preliminary objections raised by the counsel to the first and the third defendant. With due respect to the learned counsel for the second defendant, pre-action notice is only applicable to the first defendant and does not in any way affect the case of second and third defendants. From the claimant's pleading, this suit can survive even with the absence of the first defendant. Moreover, the first defendant did not properly raise objection in respect of non-service of pre-action notice, only made it as a ground, but never argued it. And failure of the first defendant to challenge the competency of the suit in that regard amount to waiver, and this court therefore treat it as mere irregularity. The second defendant, who is not entitled to the pre-action notice, cannot be allowed to raise it. See the case of Niger Care Development Company versus Adamawa State Water Board. And in the case of Mobile Producing Nigeria Unlimited versus Lagos State Environmental Protection Agency, it was held that a suit commenced in default of service of pre-action notice is incompetent as against the party who ought to have been served with the pre-action notice, provided that such party challenges the competency of the suit. However, a party can decide to waive the requirement to be so served. In that case, non-service becomes mere irregularity, where a defendant insists a pre-action notice becomes a condition precedent and must be complied with to vest jurisdiction on the court. Can all the appellants claim they all are entitled to pre-action notice? Obviously not. The only party with semblance of, I'm quoting from that case, the only party with semblance of being qualified is the 14th appellant. And even at that, and following from the resolution of issues 1, he was not acting under the authority, or he lacked authority to do what he was alleged to have done, and therefore cannot claim pre-action notice, which in any case must be served on the governor as stated in section of Enudem and another versus Umo citations provided. In view of the above, therefore, the second defendant submission regarding pre-action notice is hereby discountenanced. Finally, this issue is resolved partly in favor of the second defendant and partly in favor of the claimant. With regard to the claimant's issue 3 in his reply to the second defendant's notice of preliminary objection, this issue is incompetent as it does not affect in any way the defendant's pleadings. The second defendant can file a notice of preliminary objection challenging the competency of claimant's suit even without filing a statement of defense. Also, in preliminary objection, the respondent can only reply but not raise another objection in a preliminary objection. The claimant's objection is therefore incompetent and struck out. In conclusion, issues 1 is resolved in favor of the claimants against the defendant, and issue 2 is resolved partly in favor of the claimant and partly in favor of the defendant. Accordingly, the second defendant preliminary objection is hereby overruled to the extent, except on issue of tort of defamation, which I resolve in favor of the second defendant. I shall now proceed with the main suit. This one is very lengthy, so I will take the main points to reach the judgment. The crux of the claimant's case is that he was employed as cleaner by the second defendant and redeployed to work in the first defendant office. First defendant is the principal of the second defendant and employer of the third defendant. That is, the second defendant is an agent of the first defendant. The claimant was employed by the second defendant as cleaner since 2018 and has been in the service until the incident that led to the termination of his appointment. According to paragraph 4 of his statement of facts, he stated that he started with salary of 17,000, and in the year 2020, it was increased to 22,000, and in year 2022, his salary was further increased to 28,000 per month as cleaner. That he was instructed by one Mrs. Juliet Israel Ikwemi on the directives of the third defendant together with 3 other cleaners or other cleaning staff to kill and clean 4 chickens. She bought pursuant to the directives of the claimant. Pursuant to the directives, the claimant killed and cleaned 1 of chickens and handed over to the driver of the third defendant. Later in the evening, the claimant was called that some chickens' parts were missing. Thereafter, without proper procedure, his employment was terminated via SMS. The action of the third defendant that the claimant stole chicken legs is very defamatory and intended to lower the character of and integrity of the claimant in the eyes of the reasonable person. The law is that a party who is claiming relief in court generally has the burden of proving the existence of facts upon which he is basing the grant of his claim. The legal burden of proof is that burden which the law places upon a person who will have judgment delivered against him if no evidence was laid and the pleadings before the court. This person is usually the plaintiff or claimant or petitioner, as the case may be. He is expected to adduce cogent and convincing evidence in proof of his case. See the cases of Biopeace Enterprises Limited versus NDIC, Okoye versus Nwanko, all citation presentation National High School versus Ogbego, all citations provided. The general rule is that plaintiff should succeed on the strength of his own case. His case crumbles and remains unproven where he fails to do so, and should not rely on the weakness of the defense. Once the onus is discharged, it then shifts to the adverse party. The burden of proof of a particular fact continues to shift between the parties until all the issues in the pleadings have been dealt with. The onus is on the party against whom judgment would have been given if no further evidence were alluded. See Andrew versus INEC, Egunike versus ACB Limited, all citations provided. Also, the first and second reliefs in the claimant's case are declaratory in nature. The law is that persons seeking declaratory relief must to prove it with cogent, convincing, and reliable evidence on the strength of his own case and not on the weakness of the defense. In the instant case, it is obvious from the pleadings and evidence adduced by the claimants, as rightly pointed out by the defense, there were concealment of facts and contradictions. The claimants was unable to plead material facts and lead evidence to establish the employment relationship between him and the defendant or second defendant. No letter of employment, no evidence to show that his contract of employment with the second defendant was entered orally. He failed to plead and lead evidence regarding the terms of employment so as to show in which manner the defendant breached the terms of their contract of employment. Claimants pleaded that he was employed by the second defendant in 2018, and the contract agreement between the second defendant and the first defendant, pursuant to which the claimant was employed, was executed in 2022. Claimant concealed the fact that he started working with a cleaning company before the said company was disengaged by the first defendant, and thereafter, second defendant was engaged by the first defendant. The claimant failed to establish the relationship between the first and second defendant as principal and agent as he alleged, and not clients and independent contractor as contended by the first and second defendant. Even during cross-examination, the claimant, he confirmed that there was a mistake in his pleadings. With all these discrepancies and contradictions in the claimant's case, the claimant's evidence is unreliable. In proof of the relief sought, I also hold that the totality of the evidence adduced by the claimant in proof of his case are not cogent, convincing, or reliable to entitle him the relief sought. Therefore, the burden of proof that is squarely on the claimant has not been discharged to entitle the court to consider shifting the burden on the defendants. I already stated earlier in this judgment that this court lacks jurisdiction to entertain claims bordering on defamation of character. The claim is accordingly struck out. The other reliefs are hereby dismissed for lack of proof. Parties to bear their respective costs. Yes. I am shorting it because analyzing the evidence, it will take a long time, and it's already 5 o'clock.
So that we are very grateful for your very well considered judgment. Lord touch on every aspect of the matter, all issues, all grounds raised. Lord was monstrous to touch on. The Lord, we learn every day. I'm most grateful, sir.
All right.
I love life.
All right. Okay.